What is the Land Expropriation Bill and why is it necessary? Land expropriation is a controversial topic. Expropriation is the process of putting privately owned property in the hands of the government for the public good in return for just and equitable compensation. It's been acknowledged by the Constitution of South Africa as a means for the state to proceed with land reform, land redistribution and service delivery. Now, every citizen should have access to land on an equitable basis. Now, the current and proposed legislation. The legislation in force is still the Expropriation Act of 1975, which had racist motivations. This act allows compensation at market rates, which arguably is in conflict with the Constitution, which requires just and equitable compensation. New legislation to correct the imbalance has been with the National Assembly legislative pipeline for some time and has undergone several revisions. The current bill was introduced to Parliament in October 2020 following a public consultation process. It recognizes unregistered rights as a feature, not in previous versions. Although the bill has undergone several revisions, the objective remains to provide a uniform and fair procedure or framework for all expropriations within the provisions of the Constitution. Now, expropriation without compensation. Section 12.3 of the bill sets out the circumstances where it may be just and equitable for nil compensation to be paid, including but not limited to where the owner does not intend to develop vacant land, but to benefit from an increase in market value. Where an organ of state holds land that is not being used for its core function, where the owner has abandoned the land by failing to exercise control over it, where the market value of the land is equal to or less than the amount of state investment or subsidy in the land, and when the land poses a health, safety, or physical risk. Now, there's widespread legal agreement that this section does not apply to ordinary private property that is used or being developed and adequately cared for. Considerable case law of the meaning of just and equitable has developed over the years, which will be considered in the application of this section. However, there are still several concerns. Firstly, it's not a closed list, but a set of non-exhaustive guidelines that allow for unspecified relevant circumstances to be considered by the expropriating authority. Secondly, there appears to be an unstated and unsupported presumption that all privately held land is developed or otherwise capable of development. Furthermore, it's unclear as to how these guidelines will impact on land set aside for conservation purposes. Thirdly, it's unclear whether the usual legal meaning of abandon will apply or whether a wider definition will be applied. For example, will the owner be considered to have abandoned the land if they leave out of fear of their safety? It's likely that the skeletal section 12.3 will be fleshed out by regulations, but if promulgated and applied in its current form, it will almost certainly lead to extensive legal wranglings in the courts, including several challenges on constitutional grounds. Furthermore, the uncertainty over how section 12.3 will be applied will cause further negative impacts, and whatever the final form of the bill will cast a shadow over the agricultural sector for several years to come. Now, promoting economic development or undermining investor confidence. The ANC has pushed this agenda for some time, arguing that changes are needed to address racially skewed land ownership patterns dating back to white minority rule. Speaking on the 8th of January, the President Cyril Ramaphosa said that land reform process will promote economic development for the benefit of all. Some experts feel the Constitution will need to be amended to allow this, while others disagree. Most opposition parties have rallied against the ANC's proposals, saying they undermine property rights and investor confidence in South Africa. There are also concerns about the capture of government ministers. Now, who will monitor the implementation of the bill when it becomes law? That remains the question.